court notes that there was a motion for a bond reduction that was filed by the defense in this matter approximately 2 days ago. Has the prosecution received a copy of that motion to reduce bond?
Yes, Your Honor.
Mr. Wood, is the prosecution objecting to that being heard here today?
No, you're not. No, we're not, Your Honor.
All right, we'll hear the motion to reduce bond then today. Ms. Elcox, are you going to be arguing that?
Yes, Your Honor.
You may proceed with your argument. I want you to know that I have reviewed your motion. I've also reviewed Title 19, Chapter 29, and Idaho Criminal Rule 46.
Thank you, Your Honor. Your Honor, we are asking that the court today set bail in the amount of $10,000 consistent with what Lori's attorney in Hawaii requested. In the event that the court is not inclined to set bond in the amount of $10,000, we are asking that the court consider setting a bond no higher than $50,000 in this case. Lori is presumed innocent as she stands before the court today. The fact that she is presumed innocent is not a loose guideline. It's a foundational principle of the American criminal justice system. Under both the 8th Amendment to the United States Constitution and Article 1, Section 6 of the Idaho Constitution, excessive bail is prohibited. Judge, you are the gatekeeper in this case. You're the guardian of the presumption of innocence and the constitutional rights afforded to Lori. This is not a court of public opinion. This is a court of law. And are we going to let our citizens' rights be dictated by what appears in the media? Bail must be set in an amount that assures Lori's appearance in court and is commensurate with the charges that she is actually facing today in court. A $5 million bond is unreasonable, it's astronomically excessive, and is the functional equivalent of holding Lori without bond. This is a violation of Lori's constitutional rights. I can tell the court that in my almost decade of practicing law as both a prosecutor and a defense attorney, I have never seen the crime of desertion charged. This is because abandonment issues are generally dealt with under the Child Protection Act, not the criminal code. But even under the desertion criminal statute, which Lori has been charged with and faces these charges here today, the maximum fine, as Your Honor said today in court, that can be ordered is $500. Yet her bail is set at $5 million, 10,000 times the maximum fine in this case. In a recent Madison County murder case, the bond was set at $1 million. In the 5 counts the court read today, charged in the criminal case, there is not one allegation of a crime of violence. A bond set this high denies Lori due process and fundamentally deprives her of her ability to meaningfully participate in the defense of these allegations she faces. It is clear that the government just needed to find a charge that would fit in this case because of all of the media attention surrounding this matter. The last thing that should happen is to allow this case to be tried in the media and to allow public opinion and rampant speculation to dictate how this case proceeds through the judicial system. Considering the purpose of bail, to which Lori is entitled as a matter of right, Idaho Criminal Rule 46, as Your Honor referenced, lists the factors that the court should consider when determining the appropriate bail amount to set in this case. Pursuant to those factors, Lori's bond should simply be reduced in the amount requested because she has no criminal history whatsoever. In fact, Lori took the initiative while she was in Hawaii to contact law enforcement and say, in the event that a warrant issues, she will voluntarily turn herself in. Police did not afford her that opportunity to do so. They created a spectacle out of the situation when they knew that Lori had contacted law enforcement and indicated that she would turn herself in. She waived extradition in this case. She did not fight returning to Idaho. She has hired 3 criminal defense attorneys from 2 different law firms, and she is dedicated to vigorously defending against these allegations. We, as her attorneys, also agree to assure Lori's presence in court. Chad, Lori's husband, has returned to Idaho to his home of his own volition, and Lori and Chad maintain a residence locally. That home was purchased over 5 years ago, or approximately 5 years ago. Chad, their children, their children's spouses, and grandchildren are all located locally. Furthermore, Lori's passport is expired. She has no flight risk whatsoever, and this assertion that when this investigation began, when there was initial law enforcement contact, that she fled to Hawaii is unequivocally false. That was a planned move. We believe that the evidence will show that, will establish that. It was a planned move to a place that she had previously lived, and she moved to the exact same neighborhood in which she previously resided. Furthermore, Lori's history demonstrates that she has a consistency in her residences. She lived in Austin, Texas for almost 20 years, worked at the same salon for 15 years. She then moved to Chandler, Arizona, where she resided for 5 years in the same house. She worked as the director for Broadway Kids, an organization that puts on summer camps for children, and she also taught group fitness. Between 2014 and 2018, she lived in Hawaii until she returned there this fall. Lori's history demonstrates that she has consistent, long-term residence and a long-term employment in those places that she's lived. Further, Your Honor, there is probably no greater assurance that Lori will appear before this court and any other court assigned to preside over this case because of the droves of people that she has following her every move, even before she was charged. She has TV cameras in her face. She has people following her. It is built-in pretrial monitoring to a level I have never seen before. It's more effective than any sort of surveillance that law enforcement could put on her. She cannot go anywhere without cameras and people scrutinizing her every single move. She poses no flight risk whatsoever. She is intent on defending against these allegations and proving that she is innocent, despite the fact it's the state's burden to prove her guilty beyond a reasonable doubt. If the intent of the high bond as originally set in this case was to ensure that Lori was transported back to Idaho, she is back, and as I stated, she is eager to defend against these charges. Regardless as to whether she has been tried and convicted in the court of public opinion, Your Honor, here today, Lori is innocent. Lori will absolutely abide by any pretrial release conditions, any sort of monitoring that the court requires, but there is simply no basis for a bond this high, and it must be reduced given the charges that she is facing. For those reasons, Your Honor, we would ask that you grant the defendant's request to reduce bond.
Ms. Selcox, just so I'm clear, if your client were to bond out, I don't need her address, but where would be her expected place of residence be?
She'll be residing locally, Your Honor. I can provide that address to the court under seal if the court would like to do so, but given the media attention, I would rather not put that on the record.
I understand. Thank you. Mr. Wood, do you wish to be heard?